Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we will be looking at majority verdicts in criminal trials. As further scrutiny and criticism of majority verdicts in criminal trials re-emerge, we thought that perhaps you would be interested in knowing more about this subject. Do juries in England and Wales require a unanimous verdict for deliberation? And do majority verdicts align with the criminal standard of proof of beyond reasonable doubt, or in other words, being sure? Is there a link between majority verdicts and wrongful convictions? Were majority verdicts introduced and motivated by a desire to dilute the influence of minority ethnic people and the labouring class serving on juries, as some researchers suggest? What is the stance in other common law jurisdictions? In this video, which given the length will be published in various parts, we explore all these questions and more. We are also excited to have as our guest Professor Emeritus of Mathematical Statistics, Richard Gill, who will join us to understand whether there is a higher risk of miscarriage of justice in majority verdicts. So be sure to stay tuned and follow us until the end for a comprehensive and informed perspective. Also, like and subscribe if you find our videos useful. So let's start with jury deliberation. What is the position today? Before 1967, verdicts in criminal jury trials in England and Wales could only be unanimous. Today, majority verdicts are allowed. Originally introduced by Section 13 of the Criminal Justice Act 1967, majority verdicts are today allowed by virtue of Section 17 of the Juries Act 1974, which states, subject to subsections 3 and 4 below, the verdict of a jury in proceedings in the Crown Court or the High Court need not be unanimous if, in a case where there are none less than 11 jurors, 10 of them agree on the verdict, and in a case where there are 10 jurors, 9 of them agree on the verdict. Subsections 3 and 4 states that the Crown Court shall not accept a verdict of guilty by virtue of subsection 1, i.e. by majority verdicts, unless the foreman of the jury has stated in open court the number of jurors who respectively agreed and dissented from the verdict. And subsection 4 says that no court shall accept a verdict by virtue of subsection 1 and 2 unless it appears to the court that the jury have had a period of time for deliberation as it thinks reasonable with regards to the nature and complexity of the case. And the Crown Court shall in any event not accept such a verdict unless it appears to the court that the jury have had at least 2 hours for deliberation. When the jury first retires to consider their verdict, they will be told that only a unanimous verdict can be accepted. The Criminal Practice Direction 2023 8.6.1 states, before the jury retires, the judge must direct the jury to this effect. As you may know, the law permits me in certain circumstances to accept a verdict which is not the verdict of you all. Those circumstances have no arisen, so that when you retire, I must ask you to reach a verdict upon which each one of you is agreed. Should, however, the time come when it is possible for me to accept a majority verdict, I will give you a further direction. The further direction referred here is known as the majority direction. When can a majority direction be given? So As you probably know, jury is generally composed of 12 jurors. However, this number may reduce due to jurors falling ill or due to other factors. The number of jurors cannot be reduced below 9. A jury formed of 9 jurors cannot be directed as to the majority verdict. So, for a majority verdict to be directed, the jury must be composed of 10 or more jurors. Also, a majority directions cannot be given until at least a minimum of 2 hours of deliberation. However, this time has now conventionally become 2 hours and 10 minutes, as we can see from the Criminal Practice Direction 2023. It is important to note that though this is the minimum time required, in practice the judge will have discretion to decide, in accordance with the specific circumstances and complexity of a case, when it is appropriate to accept a majority verdict. Generally, the judge will discuss this with both prosecution and defense. So, if it has come apparent that a jury composed of 10 or more jurors after at least 2 hours and 10 minutes of deliberation cannot reach a unanimous verdict, then the jury are called back into court and are told that a majority verdict can now be accepted. They will be explained at this point of the majority required in the specific case, depending on the number of jurors deliberating. So, if the jury has 12 jurors, then the majority verdict can be 11-1 or 10-2. If it has 11 jurors, then the majority verdict can only be 10-1. And if it has 10 jurors, then the majority verdict can only be 9-1. But what are the most common criticisms to the majority verdict direction, and why some are so vehemently opposed to it? First, let's put the issue into context by weighing its scope. So, how many jury verdicts are deliberated by majority? We know that from Section 17 and the Criminal Procedure Rules that jury must state in open court the number of jurors who respectively agreed to and dissented from the verdict only in guilty pleas. So we do not have that number for acquittals. This seems to have been a deliberate decision to protect those acquitted so as not to cast doubt on their acquittal, which in itself is highly contradictory when guilty pleas by majority must be accepted and no doubt can be inferred. Nonetheless, given this rule, we only have that figure in relation to guilty pleas. According to an article published in February 2010, Our Jury Affairs by UCL Professor Cheryl Thomas, we understand that juries return majority verdicts in 19% of all guilty verdicts. According to a more recent article titled Majority Jury Verdicts in England and Wales, a Vestige of White Supremacy, to which we will refer in more details later, that figure amounted to between 12 and 16% in each year for Crown Court convictions following a guilty verdict on at least on one count in the years between 2014 and 2019. This amount to 9,516 convictions for the 6 years period and between 1,180 and 1,887 each year. So why was there a departure from the unanimous verdict in England and Wales in 1967? Majority verdicts were contemplated for the first time in a clause within a proposed criminal justice bill in 1966. From analysis of the Hansard archive, one can see that this bill was discussed in Parliament in several Common and Lord sittings between 1966 and 1967. On the 12th of December 1966, Roy Jenkins, the then Secretary of State for the Home Department, presenting Clause 10 relating to majority verdicts, first introduced the change with a generalized statement that the principle of unanimity was based on the fact that if the defendant lost, he was subject to the most horrific penalties, for example, the death penalty, and suggested that we can now be more relaxed given that we have moved away from that, suggesting that loss of liberty, loss of reputation, isolation, and moral injury resulting from being convicted for a crime one did not commit seems somehow a penalty one can relax about. Rather poignantly, in a later Lord sitting on the 10th of May 1967, Lord Stohill stated, "It makes no difference whether he is faced with the death sentence or faced with the shortest curtailment of his liberty. It is vital to our democracy and criminal system that nobody is deprived of liberty after trial by jury unless certainty has been reached." Let aside those opening points that the Secretary of State made at the time. He introduced the majority verdicts based on two specific arguments. One was that according to the Home Office Research Unit's estimate for 1965, 37% of jury trials resulted in acquittals. About 3.5% or 4% of the cases which go to juries, also there is jury disagreement. That is disagreement which cannot be resolved by the ordinary process of argument and persuasion within the jury room. He was concerned that most of these cases were big criminal conspiracy cases affecting men who perhaps do not commit acts of robbery or violence themselves, but worse, they organize others to do it for them. They are the men who are the most difficult to get into the dock, but whose conviction will be vital to break up the serious crime networks in London and other big cities. He gave a more detailed analysis focusing on the Central Criminal Court, which dealt with about 5% of all trials on indictment. He said that in 1965, in that court, there were 49 cases of jury disagreement. In 25 of those cases, a second trial resulted in agreement and conviction. In 14 of them, in agreement and acquittal, and in 9 of them, in a second disagreement and no further proceedings, therefore. One case did not go to a second trial. He said that these numbers were supportive arguments in favor of majority verdicts, as this would alleviate the substantial consumption of time for the police and others involved in second trials. But he gave a second and more important argument. He maintained that whilst in some cases the disagreement were caused by perverse jurors, i.e. those with a grudge against the police or the judicial system, there was a more emerging trend of 1 or 2 jurors effectively being bribed by criminals to frustrate the process of justice. A trend that in a later Lord sitting in May 1967, Lord Stoneham described as a really grave and mounting problem of deliberate corruption or intimidation of jurors to secure a vote for acquittal. It is not surprising that against this background, those arguments in support of the introduction of majority verdict gained the support from the general public, as it was shown by a survey of public opinion conducted by the Gallup poll with 72% in favor of majority verdicts. However, those in Parliament opposing the change found that the evidence of jury nobbling, i.e. bribing of jurors to obtain a certain result, provided by the Secretary of State was that at the best unconvincing and at the worst totally lacking. Some found alarming that 1/3, that is 14 of the 49 cases mentioned by the Secretary of State, result in a second trial in acquittals. Effectively, with the introduction of a majority verdict, those cases will now result in convictions. It was also noted that even though somebody may have nobbled a juryman and bribed him, even though such a person may have obtained disagreement on one occasion, there is no evidence at all that he will finally secure the man's acquittal by a second trial. On the 10th of April 1967, Mr. Deeds made a motion to strike Clause 10 out of the bill on the basis that little or no evidence in support was offered by the Home Secretary in relation to the most important issue that was put forward in support, namely the jury nobbling. He observed that against the comparable changes which have been made in our law in recent years and the thought given to them, this has undoubtedly been the least considered and the most hastily reached. Having read in great detail the supporting evidence or lack of in favor of majority verdicts to address the apparent emergent issue of jury nobbling, I came to the conclusion that this decision was taken more to satisfy an administrative advantage of avoiding second trials. However, there may have been even a more obscure reason, not clearly spelled out during parliamentary debate, which may explain the lack of evidence of the apparent argument behind the majority verdict rule. We will discuss this later in our next video. But pausing there for a moment, can it be said that the majority verdicts undermine the criminal standard of proof of being sure, or in other words, beyond reasonable doubt? Join me next week when we will be discussing this with Professor Emeritus of Mathematical Statistics at Leiden University, Richard Gill. We will also touch upon a research which seems to suggest that majority verdicts may have been motivated by a desire to dilute the influence of minority ethnic people and the labouring class serving on juries. We will look at this issue in our next video, so be sure to hit the notification bell below to be notified when our next video is out. I hope you have found this video interesting, and if so, like it and also subscribe to this channel to help us with our mission to humanize wrongful convictions. Also, join our networking hub at spokeninjustice.net to take part in our roundtable discussions on issues that concern our criminal justice system. We look forward to usher you as we sit and rise in this unique trial.